of the people in attendance and the great presentations and Q&A, so I hope we can have some of that in this session as well. So let's see, I know that John Pollock, my good friend and colleague John Pollock, gave a great introduction this morning to the recent developments in the right to counsel movement, and many of those I think overlap with why there's an interest in pilot projects now. I know that John talked about the dreadful Lassiter case, and we can all take a moment now just to hiss for Lassiter. It's in my top 5 worst Supreme Court cases of all time list. And in the post-Lassiter decades, the turn of the right to counsel movement, certainly away from any kind of federal court strategy, away from any kind of Supreme Court strategy, toward looking at state court issues and toward looking even at non-judicial initiatives. And that is certainly, those are certainly things that have contributed to the interest in pilot programs. So starting, I think, in that post-Lassiter era and certainly going through the 2006 American Bar Association resolution embracing the idea that jurisdictions should adopt a right to counsel in basic human needs areas. That's another factor that's contributed to the interest in pilots. It's striking to think, of course, about the difference between what the Supreme Court has doctrinally identified as fundamental rights through its jurisprudence and what people, especially poor people in this country, really even care about, right? There's a big disconnect there. And so the basic human needs framework has almost no overlap with the federal fundamental rights jurisprudence, but has become the centerpiece of the right to counsel movement. And so the 2006 ABA resolution encouraging jurisdictions to endorse a right to counsel in those basic human needs areas, and many of the pilots and many of the other non-judicial initiatives around the country have adopted that framework. There have been, I think, notable successes. I mean, we've seen, on the one hand, test cases in several states attempting to pick out a particular area of law and try and achieve a judicial pronouncement of a right to counsel in that area of law, generally based on state law. And we haven't seen a lot of success in those areas. Not to say they've been abject failures. We've had cases where, there are a number of cases where the courts do things like like Maryland case, Fraser v. Barnhart, the court finds a way to rule for the litigant in front of them without reaching the larger issue of whether all such litigants deserve counsel. And many times along the way we get good judicial pronouncements about, this is not justice. In the Fraser case, for example, there's a wonderful concurring opinion saying, one of the justices saying, I don't believe any justice on this court thinks that justice is equal between rich and poor. And we're starting to see more of those judicial pronouncements. But as a strategy for actually broadening the right to counsel, test cases haven't been that successful. On the other hand, legislative strategies have been rather successful in recent years. We've seen a lot of increased access to counsel, particularly in the very setting which was the context for Lassiter itself, termination of parental rights. More jurisdictions have now enacted statutes providing for counsel for parents or children in those situations. We've seen some increase in access to counsel for people with disabilities, like the court rule in Washington State that allows for the appointment of counsel as a reasonable accommodation for litigants whose disabilities preclude effective self-representation. We've seen a little bit of progress in the education area, and we've seen increased attention to this idea of targeted representation. The idea being that for whether it is for doctrinal reasons, philosophical reasons, practical reasons, financial reasons, the idea of a civil Gideon, an across-the-board sweeping statement that all civil litigants should be entitled to counsel, no one thinks we're going to achieve that soon. And so instead there's been an increase in, I think, very valuable focus on identifying which are the areas where representation will make the most difference, who are the most vulnerable litigants, which cases have the highest stakes in play, where is the imbalance between representation between plaintiff and defendant most egregious, where does that imbalance most likely contribute to miscarriage of justice, and all of those things have led to an increased interest in actually getting that information rather than speculating about where that's likely true, but actually trying to acquire that information. So given the increased attention to targeted representation, given the increased turn to non-judicial initiatives, including in particular legislative ones, I think that It creates a data impetus, it creates an impetus toward getting data that will support these initiatives, and it creates an impetus for pilots. So if I had to, when I teach classes, I know that students love lists, and so therefore I'll give you a list. I think we could say there are at least 5 sources for the increased interest in pilot projects in recent years. One of them is the general trend toward evidence-based practice, right? We saw this first in medicine, now we're seeing it in a lot of different kinds of social science fields, education and criminal justice, and it's becoming more popular in other social sciences. The law is a little late catching up there outside of the criminal justice area of the law. So this notion of evidence-based practice and really determining empirically what works and what doesn't is a little late coming to the law, but it is coming. So we're part of that trend. Certainly the defensive mode of many social service providers in this budget climate, the need to stave off funding cuts or preserve existing funding by showing effectiveness, that also drives interest in empirical data and pilots. The new or renewed focus on legislatures and non-litigation initiatives and targeted representation. The attempts to counter what we sometimes call the snicker factor, this sort of like, what are you talking about? This is pie in the sky, the idea that we would ever get representation in X, Y, or Z context. I sometimes like to remind people, well, it comes news to anyone in this room, but we didn't get Gideon because there was, a pile of money lying around with no obvious use for it, right? That's not what led to Gideon. Many things led to Gideon, but in large part what led to Gideon was a culture change, right? It became unacceptable to charge, prosecute, try, convict, sentence, and imprison a person without ever giving them access to counsel. That became, I would really venture to say, culturally impermissible. So what we now think of as pie in the sky in certain civil contexts similarly was in criminal context that way at a point in the lifetimes of some of us in this room. And we can get there on the civil side too if we do so strategically, I believe. So pilots are a way to counter some of that snicker factor or skepticism about the idea that a right to counsel is possible. And finally, fifth, they do, I think, have the power to contribute to this culture change idea, both on the data side and on the look here it is side. And that's what some of the pilots I'll be talking about today will show us. But I don't mean to suggest that we've known nothing about the effectiveness of legal services until now, or that we know nothing unless we have a methodologically sound, empirically solid, data-driven set of findings. I don't believe that, and I don't mean to suggest that. Many prior studies of the effectiveness of legal services, quite a number of them focused on whether and when counsel make a difference. A number of them focus on things like the effectiveness of different kinds of interventions, lawyers compared to something else, which builds on some of the conversation earlier today, particularly in the immigration context about non-lawyer alternatives. Quite a number on savings associated with providing counsel. And there's a wonderful article by Laura Abel in the 2010 Seattle Journal for Social Justice that collects some of the data that exists about savings associated with providing counsel. And then there are things like the Maryland Access Commission's 2011 study saying, okay, we're going to try and put a number on what it would cost to provide counsel to all litigants below a certain financial threshold in Maryland in those basic human needs area, where one side is represented and the other isn't. That figure, incidentally, in Maryland that they came up with was $106 million a year. $106 million a year in the Maryland Access to Justice Commission's 2011 study of the cost of providing counsel to unrepresented litigants below a certain income threshold in basic human needs cases where the other side is represented. So a lot of assumptions built into that about how many such litigants there would be, but I think a very valuable effort at actually trying to put a dollar figure on that. However, despite decades of different kinds of studies and surveys and analysis of different initiatives that have been tried, only one randomized study of the provision of legal services, and that was a New York housing study done about 30 years ago. Many researchers believe that randomized studies, you hear people say randomized studies are the gold standard, right? A randomized study is really the thing that tells you whether something works or not, and certainly that is the conventional wisdom in medicine and in some other fields. We've now seen some randomized studies of the provision of legal services. I'm going to talk about two that were done in Boston, and in the California pilots that are underway, randomization is part of the evaluation in some of the sites. Randomization is not without controversy, right? There's controversy over whether randomization is indeed the gold standard or the only method of achieving defensible results. There is a lot of controversy in the social sciences arena generally, but in legal services in particular, about what you can measure with a randomized study. And people in the room, some people in the room may be familiar with some of the studies. 3 randomized studies of the provision of legal services have been done by Professor James Schreiber at Harvard, a law professor and statistician. Did 2 studies on the Boston pilot I'm going to talk about in a moment, and 1 on a Harvard Legal Aid Bureau project that provided representation in unemployment insurance appeals. Those studies end up measuring, in those instances, the effect not of representation, but of offering representation to people. And so what happens to people who, does everyone who's offered representation take it, but more importantly, do all of those who are not offered representation through the study end up unrepresented? So when you compare, how did the people offered representation through the program you're studying do compared to people not offered representation through that program? And you know that the people not offered representation through that program don't get it somewhere else. So there's a certain murkiness often in these comparisons, which is often masked by this idea that we're randomized and randomization is the gold standard, and therefore, this is our ultimate proof. So there's a certain tension there between this idea that randomization is everything, randomization can give us, utterly impregnable, defensible data, and when you look closely, what you're actually randomizing, what you're actually testing. There are significant ethical issues in randomization. In many of in the Boston legal services housing studies that I'll talk about, the ethical issues were not at the forefront. The ethical issue, of course, is it ethical to deny representation to someone in order to put them in a control group and compare what happens to them with what happens to people to whom you provide representation, right? Is that an ethical issue? Well, many people believe, and I believe this, that if you're in a setting where you can't serve everyone and you are turning away lots of people, including many people with meritorious cases, then the ethical issue of turning them away because our intakes for the week are full, as opposed to because we're doing a study, is relatively minor. I am personally not troubled in a situation of such scarcity of resources by saying, we want to gain some valuable information, and so we will randomize and we will turn some people away who undoubtedly have defensible cases in order to have a control group and a treatment group when you don't have the resources to serve everyone. That's not always the case in the studies, and a couple of the pilots in California have utterly rejected randomization because their endeavor is to have a saturation model. We want to serve every client with this problem in this jurisdiction, and therefore we don't want to exclude some for the purpose of study. So ethical issues there depending on whether you are in a situation of scarcity or whether you are in the bounty of being able to saturate. And then there's cultural difficulty in some legal services programs with the idea of randomization, even in a setting of scarcity. And we're seeing this a little bit in California, even in some of the programs that are preparing to do a randomized study. It is very difficult if you have a setting like we have in some of the projects in California where you're going to randomize after intake. So you're going to first screen out the people in a housing project, for example, who have already defaulted, or who are over income, or who have, on an initial screening, absolutely no meritorious defense. So your study is going to be people in the right income scale, under 200% of poverty, who have a defense, who have not already, potentially a colorable defense, have not already defaulted. So meritorious cases in that pool. You can't serve all of them. You're going to randomize and deny services to some for the study, serve others, but there's going to be a whole bunch of other people that are being neither served nor studied. So the ethical issue there, I think, is minimized, but the cultural issue is not. The lawyers who have interviewed those clients and have placed them in the pool of, yes, income eligible, yes, merits eligible, yes, non-defaulted, now they're in the control group. Some of the lawyers are having enormous difficulty saying, but wait, they're really sympathetic. Or wait a minute, that's somebody who's got, you know, a really compelling situation. That's a grandmother, that's a person with a disability, that's the person. It's very culturally difficult for many people who are in legal services. Many of us who have been in legal services for a long time came into that because it's not easy to say, here's a problem, there's a lot of people suffering, I could help, but I won't. Right? That's how many people end up in this work. And so to say, for a study, we're going to do that is culturally difficult, even in a situation where we're not going to serve everybody. And to some degree, I think that's, you know, people don't have to look too closely when they say, okay, we're closing intake on Thursday. We're not going to hear about grandma and her meritorious case because we're closing intake. It's easier to close our eyes in that way. But it is a barrier. The cultural difficulty is something else. Okay, so let me get to the pilots that I want to talk about. I passed around a little sheet that is adapted from one that John Pollock did, adapted with John's permission, listing some of the pilots that are either proposed or ongoing. And in fact, one of them is the Judge Katzmann Working Group one in the deportation context, and then a few others on there. Those are only some of them, and not on there are the Schreiber ones that I'm going to talk about today. There's so much interest in pilots in civil right to counsel that the National Coalition for Civil Right to Counsel held a full-day conference last December, and that John organized, and has published with the Washington Appleseed Foundation a manual on pilot projects, how to do pilot projects, and it includes really thoughtful information about, you know, key considerations that stakeholders should be thinking about as they prepare to do a pilot. Available on the www.civilrightocounsel.org website. I commend it to your attention. Okay, I'm going to talk about 3 pilots. One, the recently concluded Boston pilot, and its just recently approved follow-on. 2, the San Francisco Right to Counsel City pilot, and 3, the California Schreiber pilots. So the Boston ones. 2 recently concluded, and just within the last month, funding approved for a 3rd to go forward. The 2 that were recently concluded were both in Boston area courts. They were done with, services were provided with private funding from the Boston Foundation and the Boston Bar Foundation. The evaluation was done for free by Professor Greiner and his team from Harvard. Those studies did randomize tenants into a control group and a treatment group. There were 2 different venues for the study, one in district court. In that study, the control group, the treatment group got full representation, and the control group got essentially self-help, attendance at a 3-hour tenant defense presentation and some help with materials. So one was full representation versus self-help. And the other, in the housing court, was the treatment group got what was called full representation, and the control group got what was called limited scope representation. So comparing full representation to Lawyer for a Day program. The new Massachusetts pilot, which has just been approved, is listed on that chart. I made the correction on that chart. They sought $650,000 or something, but they got $400,000 from the state attorney general through an anti-homelessness grant program that the Massachusetts Attorney General runs. And that's a 2-year project that will run in 2 courts, Framingham and Worcester, which together represent 16% of all evictions in Massachusetts, so quite a lot of, significant number of evictions covered there. Both of them will be building on the work of the Boston pilots that concluded last year. And they are being coordinated by a statewide legal services program, but services will be provided by local programs in that area. There will not be randomized review, randomized control groups in those studies. They will do evaluation based on court records following the conclusion of cases, based on client surveys, follow-up interviews. And the goal is to get detailed information on the time spent per case, firm up the data on the improvement of outcomes with representation, especially in terms of preserving housing. So that's the Boston setup. I'm going to tell you the results in a moment. Second is a very unusual kind of pilot, the one that's going on in San Francisco. This one is listed briefly on the bottom of the first page of the chart, the San Francisco Right to Counsel City pilot. Some of you may have read about this. San Francisco, about 2 years ago, passed a resolution denominating itself the nation's first right to counsel city. And what that means is a little open to question, but what the Board of Supervisors resolution says is This is a sign of our commitment to creating a judicial system that provides representation for all civil litigants where basic human needs are at stake, and identified those as custody, shelter, sustenance, safety, and health. But it was quick to warn that what this was not a guarantee that such a right was now in effect, but rather the codification of the beginning of a firm commitment to the eventual goal of providing that representation. But it is a serious effort, and the Board of Supervisors allocated $100,000 to the Volunteer Legal Services Program of San Francisco for a staff coordinator to coordinate the placement of unlawful detainer eviction cases with either staff attorneys at existing San Francisco programs or pro bono counsel from private law firms. And the thing I think that is fascinating about the San Francisco program, they are attempting to serve, and it is my understanding, John and I have a little bit of a different understanding about this, so we both need to go back and check, but it is my understanding that they are now actually serving every unrepresented, income-eligible tenant facing a represented landlord, largely through the stepping up of large firms in providing pro bono services. And one of the most fascinating things about the San Francisco pilot, which will be studied by some researchers at Stanford, but not through a randomization process, through what we sometimes call these soft evaluations of different factors. They will look at court records, they will look at outcomes, but they'll do client follow-up interviews and judicial interviews and bar interviews. One of the things that the coordinators firmly believe that they are studying is how can we change the culture of the private bar? We talk a lot about changing the culture of society to make it unacceptable that people have these very important cases and don't get counsel, or changing the culture of the courts so that the courts don't, as landlord-tenant courts are notorious for doing, just trample heedless on the rights of low-income unrepresented tenants. But changing the culture of the private bar so that the private bar says this is not acceptable to us. And one of the things that's fascinating in San Francisco, very robust commitment to pro bono in that city. Every firm in San Francisco practically participates in some organized fashion in the provision of pro bono services. But landlord-tenant has not historically been an area where firms have done that. Now, I don't know whether that's because there's lots of other sexy class action, public policy, headline-grabbing work available that firms like to do, or what. Some of it is, those cases can be difficult. They arise very, it's a summary calendar, right? So they arise quickly. There's not a lot of prep time. It requires dropping everything and turning onto this. They're difficult cases to take on a moment's notice. But firms have really stepped up their commitment to that. So it's fascinating to me that in this San Francisco pilot, one of the things that they seem to be both aiming at and actually so far achieving is a change in the culture of the bar rather than in some of the other actors in the system. I think that's very interesting. Okay, the third one is the Schreiber Project. This is by far the largest and most ambitious right to counsel pilot project that we've seen anywhere so far. It's a legislative initiative. It's a 6-year initiative. It's funded to the tune of about $9 to $10 million a year. You may wonder how anyone can fund a $9 to $10 million a year initiative in these budget climates. It was a confluence of a bunch of lucky factors in some ways, one being the now retired but then active Chief Justice with a very, very strong commitment to access initiatives, Ronald George, our former Chief Justice. One was the Governor, Arnold Schwarzenegger, who I would not characterize as hostile to access initiatives, but not particularly interested in them. But at the time, not today, but at the time, Arnold Schwarzenegger was the son-in-law of Sergeant Shriver. Justice George knew that. Justice George exploited that, and together with the sponsor of the legislation, a former executive director of one of California's strongest legal services programs, named the program the Sergeant Shriver Civil Counsel Act in an effort to shame the governor into signing it, which was successful. So I don't know whether that offers many opportunities for other jurisdictions to copy. But notably, it doesn't take any public funds. The funding for the project is all comes from funds, a surcharge on post-judgment, on certain kinds of post-judgment fees. And that's a surcharge that was not created in order to fund these pilots. It was a surcharge that was created for other purposes, notably court improvements. And a portion of it is diverted for 6 years to fund these. So not coming out of the general fund at a time when the general fund is really under enormous stress. So the The Schreiber Civil Counsel Act was signed in 2009. It required the policymaking arm of our state judiciary, the Judicial Council, to appoint an implementation committee to write a request for proposals, review the proposals that came in, recommend some for approval, and then the Judicial Council would approve them. I had the privilege of serving on that committee along with about 24 other people. And ultimately, the committee recommended and the Judicial Council approved 8 grants to legal services agencies, which ranged from $350,000 for a custody pilot serving about 100 cases a year in San Francisco, $350,000, to $2.8 million for a multi-agency housing pilot in Los Angeles County, which just served its 2,000th case in its first year. There are 6 areas of the law that are targeted by the Schreiber legislation, and they, again, track this basic human needs framework: housing, domestic violence and restraining orders, actions by parents to obtain sole custody of children, probate conservatorships, guardianships of the person, and elder abuse. Pilots were not funded in all of those areas, proposals weren't received in all of those areas. So we have housing, custody, domestic violence, and guardianship pilots in operation. The Shriver Act contains some truly extraordinary legislative findings. There's 14 paragraphs of legislative findings, and they run on for some 2,000 words. It's really quite a lengthy set of findings. And many of them are taken from the work that our Right to Counsel Committee did over the years, and that many other people in the Right to Counsel movement have done over the years in the ABA. But it's still, I think, really noteworthy that the legislature endorsed the importance of the growing size and extent of the justice gap, the gap between the need for legal services and the resources available, and a frank declaration by the legislature that the inability of many litigants to afford counsel causes injustice in some cases and threatens the court's ability to dispense justice in many others, that the lack of representation undermines public confidence in the courts and imposes avoidable costs on society, that the lack of representation is inconsistent with the requirements of a democratic society, and that the state has a responsibility to address the imbalance in access to justice between those who can afford representation and those who can't. I find that an extraordinary set of things for our legislature to endorse. However, the Schreiber Counsel Act is not a right to counsel program, contrary to how it was portrayed frequently in the press at the time that it was passed. It's not a right. It is a pilot program, and it has a set of legislative criteria. Every pilot is a partnership between a lead legal services agency and a court. So that's something that's a little unusual as well. In preparing the proposals, each one had to come from a lead legal services agency, which had to be one of our many, we have some 35 or so IOLTA providers in California, had to be one of those. But it also had to have the active participation and sign-on of a court. And it had to include a court innovation piece. So not just a, let's provide more lawyers in some or another one of these 6 areas of designated areas of law, but let's have something innovative that the courts are doing as well. And I think that was very shrewd, both because it's effective. It's effective to do that, to think about how can we make the courts more litigant-friendly, what can the courts do to improve the access situation, but also to get that kind of judicial buy-in. I think that's a very smart way to go about creating a pilot. So the pilot, the legislation embraces both the basic human needs framework and the targeted representation concept. It directs that resources for representation be made available in circumstances that echo that targeted representation concept, where there is, for example, the likelihood of a loss, an unwarranted loss of the case if an unrepresented litigant faces a represented opponent, where there is a likelihood of an erroneous decision because of that, where the nature and severity of the consequences, where the severity of the consequences are high and the nature is important, where there is a likelihood that providing legal services may reduce social service costs, and then the screening agencies are also directed to look at factors like the complexity of the case and the vulnerability of the particular litigant. The statute requires that an evaluation be performed. It doesn't require randomization. The statute doesn't require that, doesn't speak to it one way or another. Randomization will be a part of the evaluation of some of the Schreiber sites. We're going to spend about $500,000 of the roughly $9.5 or $10 million total annual on evaluation, and a report to the legislature is required in 2016 telling the legislature what has happened and noting in particular the impact of the pilot on access to justice and on court administration and the impact on families and children. So 10 projects were funded. In 2 cases, the same agency is running 2 different projects, but 10 altogether. 6 eviction projects in 3 of the state's biggest cities, LA, San Diego, and Sacramento. 2 medium-sized cities, Bakersfield and Santa Barbara, and in a small rural northern county, Yolo County, north of Sacramento. 3 custody projects were funded, San Francisco, San Diego, and Los Angeles, and 1 probate guardianship project in Santa Barbara. More than 30 new, we call them Schreiber Counsel lawyers, are now working throughout the state. 30 new lawyers working throughout the state, as well as quite a number of social workers, paralegals, and other court personnel, all funded through Schreiber. Some of the court innovations that we've seen include things like special masters or housing inspectors hired by the court to be of use in habitability cases. Chronic problem for tenants, when tenants want to make either an affirmative habitability case or a defense to an eviction based on habitability concerns, and they don't know how to prove that, or they don't have access to an inspector to go out and document that. Now there are inspectors in 3 of the counties paid for by the court with Schreiber funds to do that. Several of the projects are using mandatory mediation. One of them is using a law school mediation clinic. The Sacramento pilot is doing that with McGeorge School of Law, which has a mediation clinic. In Los Angeles, there's a dedicated court clerk for Schreiber eviction cases. So within the courthouse, there's a dedicated clerk who works on those Schreiber cases, meaning that that clerk can quickly pull the files, check for a default, look at service, just generally move the case along more quickly, help the client do that. There are social workers for the high conflict domestic violence custody cases in the LA custody project, heavy use of pro bono counsel in some of them, a bench book for unlawful detainer judges in Sacramento, location of the Schreiber Project within the courthouse itself in Los Angeles, training for judicial officers, quite a number of things that I don't know that I would say that any of them has never been done anywhere before, but collectively there's a lot of innovation for the California courts all at one time. This is a lot of very interesting measures that are being taken. Despite all those court things, Schreiber is squarely aimed at increasing representation. Right? It is not primarily about testing better self-help or better pro per facilitation or better forms or better videos or better things for unrepresented litigants. It is primarily about beefed up self-help. So what have we learned from all this so far? So out of the Boston studies, let me say first, the Boston studies are the only, am I doing that? Sorry. The Boston studies are the only ones where we have formal results so far. Schreiber came up and running just about a year ago, so there's no formal data available, but I'm going to share with you some of the informal information that we have and some of the observations that people working in Schreiber have shared with me. San Francisco, likewise, not up and running long enough to have formal findings, although what we know is that we believe that they are actually covering every one of those eligible cases at this point. So Boston, we do have published results. We have 3 publications discussing the Boston studies, 2 by Professor Greiner and his colleagues, and 1 by the Boston Bar Association task force that sponsored the studies. Very interesting findings. In the district court study, where they compared full representation to basically self-help, video and help with the answer, 66% of the full representation group retained possession of the unit, compared to 33% of the limited assistance group. So twice as often, those who got full representation retained possession of the unit. But even those who got limited assistance, 33%, that's compared to what they believed was a baseline in the single digits before that. They had done a little bit of work, mostly I think examining case records beforehand to get baseline, and it appeared that tenants retained possession less than 10%, significantly less than 10% before the study started. So really significant effects from full representation, also substantial effects from limited assistance. They also compared things like months of rent saved and payments made by the landlord to the tenant. Success in those areas as well. In the housing court, results were much murkier. This was the study that compared what was called full scope representation to what was called limited scope representation. So it was supposed to be the difference between someone actually representing you all the way through trial if the case went to trial, or all the way through discovery, motions, negotiation, and whatever else happened in the case before disposition, with a lawyer for a day program. And those results were much, much murkier. The full representation group, 33% retained possession compared to 36% of the limited assistance group. So very similar in the limited assistance group, slightly more. The full representation group saved a little less than 2 months of rent. The limited assistance group saved about 1.5 months of rent. So difference, not a huge one. What to make of this? Right? Now, some might say, well, full representation doesn't make much of a difference. The lawyer for a day is just fine, right? Look at how much better they're doing. But I think that study really points up how important it is to have a clear grasp of what we're actually measuring in each case. Because it turns out when you look closely at both the full scope representation that was provided there and the limited scope representation, they're not that different. In other words, the full scope representation wasn't that robust. Not a lot of motions practice, not a ton of discovery, not very many trials. And the lawyer for a day representation was pretty robust. Not that much difference between the service provided in those two. In the other study, where the full representation was twice as effective as the kind of amplified self-help, very much more robust full representation, much more discovery, much more motion practice, more trials. So I think those studies are very valuable because they provide, there's no question, they provide data showing that lawyers are very helpful to tenants in these situations. But they also point up how difficult it is to extract, bite-sized results that you can take to your legislature or policymaking group to say, look, here's what happens. And that's one of the worries of the legal services community, that, that things get taken out of context. Look, amplified self-help, lawyer for a day is just as good as a lawyer. Whoa, wait a minute. That is really, I think, not an accurate reading of that study, but it's one of the dangers of it. Let me share a few things that we know as a result of Schreiber, and I'm keeping my eye on the time because I'm aware that you're all thinking about what's coming next. I want to leave some time for questions. So Schreiber, no real data yet, but some fascinating observations. In Los Angeles, the core of Schreiber Counsel was anticipating that they'd be doing more trials, right? That when you have representation, you're going to do more trials than unrepresented litigants are going to do for themselves. In fact, they're doing fewer trials. They're doing a lot more motions, but fewer cases are going to trial. Now that actually makes sense from a lawyer point of view, right? We don't need trials very often. We only need trials when we have a question of fact, and then we do robust discovery and motions practice. Often we resolve those questions of fact and we don't need trials. But that's a nice thing to show to courts, right? That's a big saving of court time when we have fewer trials. In Los Angeles, the very preliminary numbers, tenants seem to be getting successful results, which either judgment for the tenant, dismissal of the case, or pay and stay, about 30% compared to well under 10% before. Very different than the 66% out of Boston, so certainly we want to think about those more and find out why that is. But a very significant rate of success for represented tenants in Schreiber. Quite a number of things in the way of culture change. In Los Angeles, for example, there's a small landlord bar that represents many, many of the landlords. We have a lot of large units, a lot of low-income people in the city live in big slum units in downtown Los Angeles or other places. Many, many dozens of units in the same building, so landlord may have many actions at the same time. A small core of landlord attorneys represents many of those landlords. And there was this literal landlords are in the club feeling in the courthouse. The landlord lawyers sweep into Department 93 in the morning and they come through the bar and they all sit there and roll out their stuff and make themselves at home, and the court calls the cases, and there are no tenant lawyers. Pre-Schreiber, very few tenant lawyers ever there, and certainly not that kind of we're in the club, please accommodate our Schedule 2 judge feeling. That has changed. Now the tenant lawyers are in the club. They sweep into the courtroom and open the bar and sit down and roll out their stuff too. And there is a palpably different feel about that. One of the things in California that's been a big problem over the years is the unlawful detainer registry. The publication, the for-profit publication, where It's like so many pernicious levels of making money off low-income tenants, right? First they get evicted, and then they get on the UD registry, and then landlords check the unlawful detainer registry to see if the tenants ever had a judgment against them, and if they do, they don't want to rent to them. So it's like a blacklist. It's like a tenant blacklist. And many years ago, when I was at the Western Center on Law and Poverty, we had litigation over whether we could stop the UD registry, and the result of that litigation, probably correctly under the First Amendment and open courts, is that you can't unless the court record is sealed. What we have now is a pretty good process for allowing court records to be sealed in many instances. So when tenants have lawyers, they can often get the record sealed, so that even if the tenant loses, they don't have that judgment against them. It's available to someone, maybe, if you know how to go down to the courthouse and get it. Even then, with a sealed record, you're not going to get much, but it's not going to appear in the unlawful detainer registry. Now, with more lawyers, more of those records are being sealed, and interestingly, the Schreiber Counsel's report, that judges are asking unrepresented tenants to see, would you like me to seal that record? So a change in what the court is doing, even where there isn't representation as a result of the representation in some of those cases. So that's sort of interesting. In Sacramento, electronic filing is now available for tenants as well as landlords. It was previously only available for landlords. We've had problems in other California courts with mandatory e-filing. That's a big problem for litigants who often don't have access to the necessary resources for that. But it's also a problem if you can't use it at all. It makes it much harder to be a tenant lawyer than a landlord lawyer if you've got to run down to court every, pay a messenger to go down to court every time you need to file something versus doing it in an e-filing way. In Sacramento, Shriver has led to e-filing for tenants as well as lawyers. In LA, I mentioned already in San Francisco, the increase in large firms stepping up to do unlawful detainer representation. In Los Angeles, there's one firm, Manette, Phelps & Phillips, one of the big law firms, that has decided that they want to be the pro bono core of Schreiber in Los Angeles. So they've put a lot of attorney resources into stepping up to be the pro bono core. And just tell you a couple of observations about the probate situation, and then I'll close. The probate pilot in Santa Barbara County is fascinating. Rather than being a comparison of what happens to, sort of who wins a probate guardianship, right? You don't really win or lose a probate guardianships, let me just say in case anyone's unfamiliar with them. The probate guardianship is your typical probate guardianship situation for a low-income person who comes to the Legal Aid Society is grandma needs a guardianship over grandkids. Mom and dad have returned to their native country, are imprisoned, are on drugs, are on the street, are whereabouts unknown, are working in the field somewhere. Mom and dad are out of the picture. Grandma needs a guardianship in order to get medical care for the kids, or enroll them in school, or just generally get a passport for them. She needs to take them somewhere. Grandma needs that in order to take care of these kids. In one of the rural courthouses in Santa Barbara County, the Schreiber attorney reported to me this week that in their examination, in preparation for creating their pilot, they did an examination of court files to see how hard is it for an unrepresented person to get a probate guardianship, an uncontested probate guardianship, right? They're contested when, mom says, no, don't give grandma custody, but your typical case is the uncontested one. Mom's gone, or whatever, dad's gone. Grandma needs to get the guardianship, no one's contesting it, but grandma can't get through the process. So they saw that the typical number of court appearances for an unrepresented Spanish-speaking litigant, 13 court appearances to get an uncontested probate guardianship. And one case had 23 court appearances. That is not a good use of anybody's time. There's no court that wants to see a litigant 13 times on an uncontested matter. So their pilot is truly a pure access pilot. It's not about really leveling the playing field. It's not about whether you're losing cases you should win. It's not about, the sort of outcome of the case in the win-loss sense. It's truly about, does this court exist for this litigant to be able to obtain something that they're entitled to and need? So they've done, before the Schreiber Project, that legal aid program did 5 guardianships. In the year before Schreiber, in all of its 3 offices, in 2012, under Schreiber, they've done 62. So they're finding a big need for this, and they're doing a lot of them. And they're keeping informal data on the effects on families, and they're finding a lot of things like helping grandma stay in Section 8 housing because she now has legal custody of the child who was living in Section 8 housing with mom who is now gone. That kind of thing. They're keeping a lot of informal data on that. Okay, so what have we learned from all of this? Evaluation is hard. It is hard to know how to measure the things that we want to measure. It's hard to get consensus on what to measure and how to measure it. Randomization is hard. Randomization may or may not be necessary. It's hard and controversial and raises ethical issues. It's expensive. It's very difficult to get somebody, Professor Greiner donated hundreds of thousands of dollars of his own and colleagues' services. It's hard to get that for free. Soft data is sometimes suspicious, but is very necessary, both for the legislative purpose of some of these pilots. You want to go to the legislature, and some legislators like the 42% of litigants have the number of court appearances reduced, and some like, let me tell you about this grandma who went to court 23 times, right? So we need both of those things, and we can get those out of studies. Pilots are, so those are some cautionary tales. Evaluation is hard, randomization is hard, randomization is very expensive. Some data will be dismissed if it isn't randomized. Soft data, I think, is necessary, but it can be hard to get and controversial. On the other hand, I think pilots are very, very attractive, right? They are a camel's nose under the tent. They are building a record that courts and legislators will find hard to ignore about whether justice is possible without representation. They provide really valuable data about costs and savings. The court cost savings that we're seeing from fewer trials in LA, fewer court appearances from contested guardianships, fewer trips fighting over service in landlord-tenant cases. I think there's no question we're going to see a lot of dollar savings that are going to be very helpful in debates. We're seeing some innovations in delivery systems, and I think that's going to be very interesting for courts. I think we're going to see a lot of courts that are going to want to copy that. We're seeing some really positive culture change that's very important. And we're seeing, and this may be one of the most important things, we're seeing an alternate reality. In the places where the pilots are aiming for saturation and full representation, we're seeing a completely different reality. What if this was really the way the courts worked? Everybody who needed representation in this area of the law would get it. And that's a really valuable thing to see. It'll be very difficult if at the end of 6 years the legislature pulls the plug on this. It'll be it'll be tragic for the clients. But I think it'll be difficult for the legislature to do it once we've seen what that alternative reality starts to look like. So I'll stop there. I think we still have some time for questions, and I'll stop there and see if we have any. Yeah?
Actually, I was wondering, in the attempts to evaluate the outcomes of the results, is there any attempt to evaluate the preparedness of the lawyers?
That's a great question. That's one of the things that came up. Can everyone hear the question? The question was, is there any attempt to evaluate the preparedness of the lawyers? And I'll take that even broader, maybe the experience and competence of the lawyers, right? There is a tendency in some of these to think a lawyer is a lawyer is a lawyer. But I think that the immigration talk earlier today pointed out, right, that certainly is not always the case. And that's one of the things that's, one piece of speculation about Boston studies is, what was the experience level of the different lawyers? So in the California projects, that is not a formal data element that is currently being captured. That is one of the elements of soft data that I think is being captured by some programs. It's a two-edged thing. Like, a lot of these Schreiber lawyers are young Schreiber lawyers. The budgeting to hire these 30 lawyers was to hire lawyers at the less expensive end of the scale. They're getting very good supervision. There was a lot of competition for those positions. These are sharp young lawyers. These are not, people couldn't get a job somewhere else. They're competitive positions. But that's very different than a 15-year housing lawyer. So you raise a great question. I think it's very difficult to capture that, and it's controversial within the culture to capture it. Yeah.
Mm-hmm. In the context of, like UDC, who has a history of our legal clinics, have you seen or do you see anything on the horizon where they're testing the efficacy or using any pilots where clinics in this regard, piloting and testing and modeling, utilizing clinics in some of these models? Whereas there you said, I think what I just heard you say, they're using young lawyers, and so they're already barred and graduated, as opposed to here where we're, each of us do 700 hours of clinic work under the supervision of an attorney. Do you see any of those horizons or any modeling or studies or proposed studies of looking at those models?
Yeah, I don't know of any of those right now. I wonder if John does. I don't see him in the room. I don't know of any now. The San Francisco Housing Pilot is using McGeorge students in their mediation clinic, and part of that will be studied, but that's not the same. They're providing mediation services. That's not students providing the actual legal services. The Boston unemployment insurance study that Professor Greiner did before the housing ones that I was mentioning, that was a study of the Harvard Legal Aid Bureau representation of UI claimants. So that was one study that did look at law student representation. There's also a law review article that a law professor named Jessica Steinberg published about Contra Costa courts, another county in Northern California, where the Stanford Law School Clinic represents tenants. Stanford Clinic does a lot of different kinds of representation, but she was comparing how tenants did. It wasn't, it was just a sort of a random sampling of cases, so there were a lot of methodological things that make it easy to attack that study, and part of that gets at, what are the reasons that clinics take a case? Are they taking the highest merit case, the highest mean cases, or the most pedagogically valuable cases, which are not always the same thing? So I think your question suggests both that clinics could be a valuable resource in expanding this kind of service, and that it would be worth studying how they do, and I agree with both of those things, but I don't think there's a lot of that underway right now.
In the Boston pilot project, the one in the housing court, when you were discussing the results between the full representation and the attorney for the day representation, the way that you talked about it and talked about the differences between them, it kind of seemed like you thought that you kind of favored full representation as opposed to attorney for the day. If that is the case, can you explain why you prefer the full?
Well, I think that did everyone hear that? I think everyone heard that. Did anyone not hear that in the meeting? Okay. I think that study, and this is not just my take on this, right? When you look at the the data and the studies and the Bar Association report and even the partner reports about it, when you look at the objective aspects of it, like what did the lawyers for a day provide in terms of motions, how often they saw jury trials, how much negotiation, what did the full representation lawyers do, it wasn't that different. So that's the problem with that one in my view, and I'm not alone in this view, is that I don't think it really adequately captured full representation model versus a lawyer for a day model. So that's the problem. But the lawyer for a day model was certainly more effective than nothing, or than the traditional self-help, right? Because they still got 38% or something retention of the unit compared to under 10% with nothing, with just the traditional self-help packet. So that was significant. It's just that we saw in the other court 66% retention of the unit with truly robust full scope. Now, it is also another caution about these studies is comparing, those are even all in Massachusetts housing courts, and there's some similarity to what they're doing, but back to this question, different lawyers, different practice standards, can we really even compare across studies? But we have to, right? We have to. We will inevitably do that. But some cautionary notes about doing that, certainly. One of the things that's interesting about Schreiber Project is that the lawyers in each of the kinds of pilots around the state have been meeting frequently and talking frequently. And they're realizing that one of the benefits of the program for them is they're developing this kind of sense of we're a core of lawyers working in this area trying to get justice for these people, rather than I just work at this agency. And so they're really doing a lot of collective strategizing about, when should you begin discovery in a UD case? When is the best time to start negotiating? What kinds of things, is it good or bad? In what circumstances is it better to ask for a jury trial or not ask for a jury trial? It's not that they're necessarily to come up with standardized answers to all those things, but it's interesting that they're asking the question. And so that's something I don't think anyone thought that was going to be a benefit of Schreiber, and I don't think that's something that's going to be captured in any sort of data about Schreiber, but it's an interesting anecdotal fact. Yeah.
When you're talking about comparing across studies and how the different practice standards and all that stuff, it makes a difference. I just find myself wondering, has there been any sort of discourse about whether or not there are friendlier jurisdictions for these kinds of studies? DC has very stronger tenant protections, and I'm just wondering if. Not to say that there's any study that's sort of front loaded for lawyer success, but it seems like there might be some that are the friendlier jurisdictions. Is that something that you could maybe practically get more like legislative support for it, especially if the laws are already sort of more, or that the legislature could use that as a sword against it, saying, well, we already have really friendly tenant laws, do we really need this right to counsel? I'm just wondering if there's any sort of conversation about that.
Yeah, I don't know of any formal conversation about that, and actually where you ended up is not where I thought you were going in the beginning, not so much about the friendliness of the laws, but the friendliness of the court. You know, it might make a difference if you have judges, you know, are you in a specialized court where the judge is a landlord-tenant specialist? And is that good or bad? Some of the judges in Los Angeles who have sat in you know, tenant housing court forever are among the worst. But some of them are former legal aid lawyers who have a different kind of understanding of the landlord-tenant situation. So there are a lot of factors about what is the court like that could go into it. And that's one of the things that this whole pilot enterprise illustrates, right? That it's seductive to think what we need is data, and we can get it and we can prove something. And in one sense, every piece of data that we get shows us that there's 100 other pieces that we need. And so there's, I think, a lot of understandable skepticism on the part of providers who say, wait a minute, we're spending $500,000 on evaluation here? Like, we know how to evaluate things in ways that don't require statisticians that might be really valuable in telling us whether something works. So there is certainly controversy over the number of dollars that can get put into evaluation. Yeah? Yes?
Have there been any studies or anybody looking at the different models of full-time legal services lawyers paired with private firms and those projects and the efficacy of those projects versus, just a panel of pro bono lawyers who gets called one at a time?
Yeah, I don't know of any studies that have looked at that. We're going to have a little bit of that in California because the projects have different uses of pro bono, so some of them have more use of pro bono and some of them are more heavily staff models. So, yeah, but I don't know of any so far. Yeah.
Has any other jurisdiction looked at the California study and started to model some of the legislative differences or even rules and regulations, and you started to be like, oh, we kind of already make this mistake, we can fix it without having to look at the study?
You mean look at what Shriver is doing?
Yes. Particularly maybe big cities like New York, who have that same population, especially in housing, as LA.
Yeah, I don't know of any. And partly, I think that's because, there is certainly informal contact. There's plenty of contact between advocates in different jurisdictions. There's informal contact between judges, right? Like, we copied New York's statewide hearings on the crisis in the judiciary, the crisis in access, and we had a set, after Judge Lippman did that in New York, we had a set of hearings like that in California. We shamelessly stole that idea. And our judges talk. But there isn't anything published yet about what Schreiber's doing and much less what is found. So there isn't an easy way for anybody to find this stuff out. So I hope that will be something that happens, but I don't know how it quite could be happening yet without a lot of really direct person-to-person contact between advocates or judges or legislators in the different jurisdictions. So I don't know. I will say that the sponsor of the Schreiber Project, Mike Fewer, an assemblyman from Los Angeles and the former head of Bethesda Legal Services, a big LA provider, did go and testify at a hearing in New York about Schreiber, but that was just when it had just been passed. So it was like, here's what we hope it will do. It wasn't anything in the nature of, here are some results. So that's a great question. I mean, I just don't know. I don't think it could be happening quite yet.
Soon, hopefully.
Yeah, hopefully. Yeah.
Well, I think many other jurisdictions have experimented with implementing some of the innovations that you've described that are being studied without necessarily studying those innovations first. And that raises the question for me is, do you think that by framing the research issue the way it's being framed, that in some ways might be playing into the hands of the critics of civil rights counsel? In other words, studying whether whether having counsel is superior to other legal services delivery models. Maybe the question should be asked a little bit in a more nuanced way: which cases are better served by full representation and which are served by other types of services, or to look at the question in a slightly different way rather than to oppose, to put the limited scope and full scope in opposition to each other.
Yeah, I think that's a really good observation, and I think we are capturing some of that in Schreiber. Because one of the things, there's a funny tension in the statute between, we want to increase representation, we believe that lack of representation causes injustice, but also this acknowledgement that we're not going to have full representation everywhere, and we need to look at what alternatives can provide. You see the phrase adequate access to justice in situations where full representation isn't available. So I think we are aiming to look at some of those things, but it's tricky for the same reasons that have been discussed earlier today. Is it, once we accept, if we accept that some kinds of clients or some kinds of cases or some kinds of settings don't require lawyers, is that going to be a ceiling on what those kinds of cases will ever get? Or is that a step on the way and that's a good thing? I don't think there's any resolution to that debate. One other thing about pilots, I was on a call the other day with someone with a great advocate from Philadelphia who was saying I don't know why everybody's talking about all these pilots. We have been doing all these things forever. We know they work. We try them when we get funds. We do this, we do that. Why are we doing pilots? And there is just a sort of a, nakedly pragmatic political reason, right? If you go to the legislature and say, give us $10 million more a year for expanding legal services, you get left out of the legislature. If you go and say, we want to do a study and really, try this and try this and try this, and then we'll see what happens, you have a better practical chance to get that. So we have some just fundamentally pragmatic reasons to do what we think will work. And if we think that selling a pilot and studying will work better than simply asking for an increase in legal services, then we'll do that. I don't mean to suggest that really I think Schreiber is just an increase hiding as a pilot. I don't think that. I think we really are genuinely studying some innovations and we really will get some interesting data. But if we thought we could have just gotten $10 million more a year in legal services, we probably would have done that. I guess maybe we're done then. Thank you.